That Mr. Bates, who's here for Russell Cooke, had asked to address me next. Is Mr. Bates here and ready? Well, then you better come and do your bit, Mr. Bates. Thank you. Yes.
Yes, sir. My name is Justin Bates. I'm standing in for Mr. Arden, QC, who can't be available today. And we're instructed by Russell Cooke on behalf of 3 core participants. There are just 3 brief areas that I'd like to address you on, if I may. The first concerns your assessors, the second concerns your experts, and the third is to pick up a question about the housing file that has been raised by some people earlier this morning.
Yes.
On the question of the assessors, we accept and acknowledge that you have decided this will not be an inquiry into social housing policy. But you have decided that you will need to look at questions of social housing management. You will need to look at questions of relationships between different kinds of managers, both the council and the TMO, and you will need to look at questions of management as between the managerial bodies and the occupiers. You will also need to look at management and procurement of works programmes. We respectfully suggest that your present assessors don't give you the expertise you would require in those fields. Mr. Montgomery is a noted urban regeneration specialist, but at the risk of oversimplifying, his experience is to identify which estate and which block needs work, not how you do that. Mrs. Redfern does have local government experience, but not directly housing management experience. The inquiry website flags up her time at Wigan, but Wigan, of course, managed their housing stock through what's called an ALMO, an arm's length management organisation. And at the risk of telling you what you may already know, where one has an ALMO, the effect of that is to put an additional layer of bureaucracy between the council and the management of its stock. So identifying one's experience in relation to having worked for a council who has an ALMO is in fact to flag up the lack of experience one has in social housing management. And as we said in our written submissions, we respectfully suggest that this inquiry would benefit from someone with active experience of housing management, and particularly tenant involvement in social housing management. And we've suggested that an additional assessor should be appointed, namely a tenant who has experience of the management of social housing. And we've given some suggestions as to where one might find one of those in our written materials. Secondly, on the question of experts, part of what I say now will be picked up later on tomorrow by the FBU, but respectfully we ask you to approve at a very early stage funding to allow core participants collectively, as was indicated earlier, to identify experts to assist now. Firstly, to comment on and suggest improvements to the letter of instructions, and your counsel this morning indicated he'd welcome that kind of input. But respectfully, the lawyers in the room don't have the experience to assist with what should go into those instructions. Secondly, as Mr. Thomas just alluded to assist with monitoring of the disclosure process, so that at a very early stage, experts can indicate what, if any, classes of documents they would expect to see that have not yet been identified. And thirdly, to ensure that all relevant lines of inquiry are pursued. So you've seen the FBU submission, for example, asking, quite correctly in our submission, why no one's been asked to comment on Part 1 of the Housing Act 2004. And Part 1 of the Housing Act 2004, as I'm sure you know, sir, is effectively now the standard against which housing should be judged, replacing the old fitness regime under the old 85 Act. That is something that the lawyers can identify. But in terms of the questions to be asked, in terms of the material to be explored, the core participants and their lawyers need access to people who actually use that material on a daily basis to feed into the relevant questions. At the risk of simplifying it enormously, the lawyers in the room, certainly the housing lawyers, can litigate about Part 1 issues, but an environmental health officer applies them on a daily basis and understands what material to be looking for. Thirdly, it was the housing file. If I may say so, that the housing file should be regarded as the Bible in the case of each tenant's occupation. It's everything that the authority or the other class of landlord holds about you, everything you've sent them, everything you've forgotten you've sent them, will be on that housing file. It will assist the solicitors and counsel assisting them in understanding the background to their clients. It will assist the individual clients in reminding them what they raised at earlier times and what points they've raised. It's not simply, or it shouldn't be, simply a repair log. It could be everything. Any letter that a counsellor once wrote on your behalf, anything you sent 5 years ago. In the case of a good file, it may even contain transcripts of phone calls that you've had with your landlord. And at the risk, again, of overplaying my hand slightly, in every housing case being heard by a district judge up and down this country today, there will have been an order for disclosure of a housing file. It's inconceivable, as a housing lawyer, that I would ever approach a case without having seen my client's file. Respectfully, if they're not to be disclosed, there should be a compelling reason for doing so, rather than an obligation on our clients to explain why information that they themselves generated should not have been made available. That was all we wanted to say, so I'm very grateful.
Well, thank you. It's very concise, and I'm grateful. Thank you.